Hey, good morning.
Morning. A few things on the agenda. The Delete Act, it looks like we're rolling with that. What are the need to knows?
Yeah, so California's governor signed that into law. It amends the CCPA. And I think for a lot of companies, they may assume, oh, I'm not a data broker. I don't need to worry about that. But it's a big deal. It's a pretty broad definition of who even is a data broker. So it's if you don't essentially you buy and you sell data and you don't have a direct relationship with the consumer. And you can think of so many different types of companies, particularly in the digital advertising ecosystem, that fall into that category and may or may not be registered currently. The California Privacy Protection Agency is going to be charged with managing the registry, taking it over from the AG and implementing regulations. But ultimately, it'll be the agency setting up a one-stop mechanism that then broadcasts out to all of the registered data brokers. You need to delete data associated with XYZ person. And while it allows the data brokers to verify identity, they still have to have a way to recognize that signal, be bumping up against this registry to get these requests, and then persist that request. So it's not a one deletion and you're done. It's ongoing. In so many ways, it's like the National Do Not Call Registry, but instead of for a single phone number, it's for all the data that you might have associated with one person. That's a lot of cost that I think a lot of companies in that space do not yet have the infrastructure to be able to respond to. They have to pay for auditors. They have to disclose that they've been audited. And there's a lot of fines associated with it. And there's just some of the very specific disclosures and data points that they now have to track and publicly disclose, I think take a very big spotlight and put it right on the industry. And that's a lot of pressure for a lot of companies.
And Elisa, the definition of data broker, is it the 500 or so that are in the California Data Broker Registry today? I've also heard 2,000 that aren't registered. So what's the easy place to look just to define it? By the way, to your point, it's data brokers that nobody's heard of, that the average person hasn't heard of, but there are some common names, some names we know in there, some familiar names, not to pick on these guys, but like ancestry.com, just because they were in the A's as I scrolled down, it's companies you know.
Well, it's not only companies you know, but I think sometimes it's not the entire business, right? Because it comes down to how do you obtain data? And maybe it's prospective lists, right? Maybe you've obtained data that you don't have direct relationships with those consumers. You've used that data in some ways to create, let's say, lookalike audiences. You're trying to understand certain prospective customers. If you don't have the direct relationship, you're both purchasing and you're selling, you could fall in scope. And maybe it's only XYZ part of your practice that qualifies as a data broker. But does your environment really tell that story so that you could defend and say, oh, yes, I've gotten this request, but it only applies to this division of the business as opposed to the whole business. If you look at the registry today, there's about 500 registered. There's several hundred more that are not actively registered. So they didn't finish through with the application. And then a whole bunch of others who we haven't seen enforcement for not registering, but $200 potentially a day, a violation. Like there are ways that it can very quickly add up to a monopoly type money scenario for noncompliance.
And then the implications for the advertising industry and brands that rely on this data, it's hard to pin a number on how much this data is used, but depending on the company, it could be anywhere between 20 and 80% of their data assets, right?
It's huge because, most companies, most brands, you have your direct relationships and you have a certain amount of data about those customers, but you're trying to understand how to personalize, how to innovate, and just the data economy. You are often getting data from other sources to help fill in some of those details, even in terms of what demographics have you not reached, and there's a lot of really positive societal benefits. You can see why that might be really important. I think it's an open question of what it does to the data economy. Obviously, there's a premium on first-party data. The whole trend of privacy laws has really driven that point home. But you think about some of the data brokers out there, and sometimes it's very niche areas of data. whether the cost of compliance, whether they can do that. So I think there's some who might opt out of just being in the industry. And then there's others that it just might consolidate into larger companies. So there's that. Yeah, I think it's a really good question. The other point that I had posted on LinkedIn that I'm kind of wondering about is the volume of data subject access requests that just regular companies, your brands might receive today. Under the California regulations, there's a pass-through obligation. So a business, if they get a deletion request, they have to pass it through to third parties with whom they've been selling. And so in the Delete Act, it only speaks to pass-throughs to service providers, but a data broker is also a business. So under the regulations, I think they'd have the obligation to pass through deletion requests to third parties. And so you have your brands who suddenly, today, maybe they get X percentage of deletion requests. And sometimes they're doing it, handling those manually. What if that's multiples increase? I mean, just like beyond exponentially increased, that they may not have the governance yet to handle at that level. So I think there's a lot of unknowns.
Well, and when does it get enforced, or when is it live?
Yeah, well, good question. So we've got a few different dates. We've got January 2026, but we'll have regulatory activity obviously before then by the agency. So we will be thinking about it and talking about it. And then there's some audit requirements that come in 2028. And then there's the public disclosure about whether you've complied with the audit requirement in 2029. And then, of course, data brokers are also subject to all of these privacy laws that just apply to businesses and potentially service providers. So it's not like that's the only thing that they need to be focused on.
Gotcha. Wow. Well, thanks, Lisa. Hey, we're running out of time here, but maybe 30, we'll dig into it next week, but maybe 30 seconds on Massachusetts and kind of the latest at the FTC.
Yeah, sure. So that is legislation we're keeping an eye on in Massachusetts. Obviously, there's other states that are in session. I think to date, we've seen a lot of the same models of privacy legislation with some variations on the edges. And Massachusetts, they're going with something very, very different. And we'll see where that goes. Every bill there gets to have a hearing. So it's just something we're watching. I wouldn't get major heartburn about it today, but it is something to watch. And then we're keeping our eye, obviously, on the FTC for lots of reasons, but there were some rumors that they may be dropping their digital advertising privacy regulations, what they call commercial surveillance. They had done some activity about that a year ago, kind of pre-rulemaking activities. So the next step would be if they actually publish and invite comments on draft regulations. So another set of potential requirements to consider.
Awesome. Well, thanks, Lisa. Great to see you. Thanks for the update.